Let's hit the pause button to welcome our guests this hour, trial attorneys Mike Jaafar and Krista Ramey. And as I was listening, I was literally reading the aggravating factor to my producer saying, yes, this is the one I want to discuss, and it's the one he just said. One of the aggravating factors. The capital felony was a homicide committed in a cold, calculated, premeditated manner, and he's just describing that this defendant did everything he could to hide what he was doing. Michael, you first. Is this a legitimate argument by the state?
Yeah, I believe it is a legitimate argument. Daniel Skin is a really good prosecutor. He started a little clumsy with his opening argument, spoke about, the Declaration of Independence and I get where he was going. But now he got to the crux, and he's using the right type of emotion, the right type of passion. He's in front of these jurors. He's looking at them. He's leaning in. So I do believe that's a good aggravating factor. But, we've seen a lot of witnesses testify in favor of this defendant on, to kind of dissuade from some of the aggravating factors. So that's what I believe.
Yeah, I agree with you. That is it enough, Michael, for let's talk a little bit about the mitigation that you referred to. Is it enough, do you think, that really, to me, what the defense witnesses did is personalize this defendant to say he has family who obviously still supports him, loves him, and tells you all the good things he's done for the family? Is that enough to have jurors say, wait a minute, he should not be put to death?
Whether or not that was enough to persuade this jury is an open question. I guess we're going to find out. But whether or not that was the right strategy, absolutely. It's the only card you can play if you're his attorney. If you don't do that, there's nothing else you can do. And as Krista pointed out, the jury came back in less than an hour. That's fast. That's really fast. And those jurors were pre-qualified. They did have to answer questions as to whether or not this is off the table for them. But I do believe that it was a great strategy. To me, if you're asking me whether or not I think it's enough, the niece testifying that he was like a father to her. She never saw him angry. She never saw him upset. He always took her to the fair. The other kid testifying that he brought me into sports. He showed up. Then the lady at the end saying that he's like a son to me. I always talk to him. There was an overwhelming amount of character witnesses that said that this guy should live. He could still provide some value to certain people. That last lady basically said, I run everything by him. I love him. I respect him. So I believe it was enough, because you only have to flip 1 out of 12 jurors. The law changed in Florida, but it's not retroactively applied. So they only have to flip 1 juror on this question, Judge Ed.
All right. I know we need to take a break. Krista, I'm going to save a question for you because you've represented children. Do you think that these individuals testifying on behalf of the defendant are really testifying against the victim?